Okay, welcome back. We are live now, as they say. Um, those over here. All right, so hope everyone had an enjoyable spring break, or at least something close to it. Um, Last class before the break, we talked about the freedom of association and associational rights, and there are three primary contexts in which this doctrine applies. Okay, the first context in which this doctrine applies is when the government compels groups to disclose their membership lists, right? And we did actually four cases on this topic. The first was NAACP versus Alabama. Remember, Alabama said as part of being a organization that does business in the state, you must disclose a list of all of your directors, all of your officers, and all of your members. The Supreme Court said no, you can request the officers and the directors, but you can't request the rank and file members because there's an associational right that people have the right to associate freely, and requiring this information to be disclosed would chill expression. Okay. The second case that we did on this point was Buckley against Vallejo. This wasn't exactly disclosing membership lists, but it was something close. That is, if you run a political ad or if you contribute to a political campaign, you must say, I, Josh Blackman, support this ad, right? You must put a disclosure. You must announce to the world that you're giving this money. And the government acknowledged that this will burden some associational rights, but the government has a compelling interest to prevent corruption or the appearance of corruption. And that requiring people to disclose their names above a certain amount of dollar threshold was not a large burden on free speech. I'm sorry, on associational rights. Okay. Then we get to McConnell v. FEC. This case was also involving campaign finance. And there the court said that requiring people to disclose, John Smith supported this ad or I approve this message, right? Indicates where the money is coming from. That's useful information for voters. And the justices agreed that that does not have an undue burden on these associational rights. As you might recall, Justice Thomas was the lone dissenter in that case, and he argued that all disclosure statements are unconstitutional so far they burden associational rights. Okay. The last case we did, you can remember way back from 2 weeks ago, was Americans for Prosperity versus Bonta, Bonta. Okay. This was a case about membership, but not directly. Nonprofits are required to submit to the IRS lists of their donors who give above a certain amount of money. It's called Schedule B. The IRS is supposed to keep that information confidential. California said, aha, we would like that information given to the IRS. And there's some evidence that the information was given was actually leaked, not intentionally, but through carelessness or whatever. The Supreme Court said that the requirement to compel disclosure of this Schedule B was a violation of the associational rights. And it said this is just like the NAACP case, right? You don't need the names of all the members. And California said, no, we do. We're trying to police fraud among nonprofits, and having this information makes us policing fraud much easier. Supreme Court said no go. And again, that case split narrowly along ideological lines. So the upshot now is that you're sort of taking decisions that were developed in the 1960s to help these sort of civil rights groups like the NAACP, and then the court's using them to help fairly large, robust conservative groups that oppose this. But by the way, the ACLU opposes this law. Lots of groups oppose this law. Okay, and this is a theme that you'll see, I think, in Justice Sotomayor's dissent. She uses this quite a lot. Times have changed. In other words, doctrines that may have established in one context to help serve one group on one side of the spectrum have sort of evolved or morphed to help on the other side of the spectrum. You'll see this theme a lot, especially when you get to the religion clauses. Okay. The second area in which this freedom of association pops up is about forcing employees to fund political advocacy, specifically public employees. This is Janus and Abood, our two cases today. If you are the member of a public sector union, when I say public sector union, you are a union employee who works for the government. Maybe you're a teacher, right? Maybe you're a healthcare worker, right? There are lots of union workers who are private. Maybe you're a police officer. Maybe you're a firefighter, right? I think I asked this. Anyone's ever been a member of a union? Public union, was it, Aaron?
Yeah.
I think you mentioned last week. Right. Did you have a choice whether to join?
Yes.
Okay, so you chose to join. You didn't have to.
Yes.
Right. Texas is what's called a right to work state, in that you're not obligated to join. A number of states actually require people to join the unions, but then the dues are a different story we'll talk about later. Okay. So again, the second category is, can government make you pay as a government employee to fund certain political activity? Okay. The third context is one that our final case is about, which is about compulsion or coercion. In other words, can you force people to engage in speech that they don't agree with? Now, the easy case is, can you force someone to salute the American flag? For example, a student in school, they pledge allegiance, right? The answer is no. That's West Virginia versus Barnett. You can't force someone to engage in speech. New Hampshire has a very famous license plate. Anyone ever seen a New Hampshire license plate? It says the live free or die state. You ever see this?
Yeah.
I kind of think that's kind of cool, right? But not everyone agrees. If you're a pacifist and you don't like this very bellicose, warlike phrase, you might oppose having live free or die. So you put a little piece of tape right over your license plate saying, I don't want this message. Can the state force you to have this message in your license plate? The court says no, right? That's Woolley versus Maynard. Okay. Another case is called Hurley. Hurley, right? This involves happy St. Patrick's Day, a St. Patrick's Day parade in Boston. And the St. Patrick's Day parade organizers, who are, I think, almost exclusively Catholic, did not want to admit a gay and lesbian group to their parade route. Right? They said having a gay and lesbian a group march in our parade would alter our message, would change the message we're trying to convey, which was overwhelmingly a Catholic message, which at the time was not very supportive of homosexual relations. Okay, the court said, "Aha, associational right. Even though the Massachusetts public accommodation law requires admission to all people, even on sexual orientation basis, you cannot force people to change the nature of their expression." Okay. There was another case, Boy Scouts versus Dale. You remember this case? Yeah, you probably remember this case. It's been around. I mean, today it's like whatever, no one even cares. But this was a big deal, right? Could the Boy Scouts be compelled to have a gay assistant scoutmaster? It wasn't about gay scouts. It was about the scout master, right? And the court again said, no. This is a private organization. They have associational rights, and you can't force them to admit someone who would go against their moral code. The way it worked is that the Boy Scouts often use public parks for their jamborees and campouts and whatever else. And they said, well, you're using public parks. It makes you public. And the court said, no. This is a private organization. But there's another case from the 1980s called Jaycees. The Jaycees, Jaycees. Anyone remember the Jaycees or even ever hear of it? It's a civic organization like Rotary. Anyone ever do Rotary? I don't know what the hell these things are, right? These are, it's on TikTok, right? These are civic. Oh, someone's laughing, right? These are civic organizations. People come together and talk about I don't know what. Right? I spoke at Rotary clubs. I don't get it. I don't go. But maybe it's not my generation. But Jaycees would not accept women into certain positions of office. I think they would accept women as rank and file members, but they wouldn't let them achieve certain positions of leadership. I don't remember the specifics. Not important now. This was a case in the 1980s, and the court held that New Jersey's public accommodation laws applied to the Jaycees, and that they didn't have a good enough reason to exclude women, and they had to require to admit women. So wait a minute. So the Jaycees have to admit women, but the St. Patrick's Day parade doesn't have to accept gay people. What you're seeing in this little sketch, this little 5-minute sketch I've given you, is that the cases sort of go over the map. They don't always line up neatly. And the Supreme Court, for better or worse, is very much a product of the generation you find yourself in. And cases from different years sometimes come out differently. Now, some people like Sotomayor says, oh, this is bad, times have changed. Look, elections have consequences. right? If Justice Kennedy was still on the court, right? I don't know that through creative came out the same way, but he wasn't on the court. Kennedy was in the court for Janus. He was lock solid on that issue. But I'm not sure if 303 comes out the same way if we still have the Ginsburg Kennedy court. So is it a sad day, as Sotomayor said, or I don't know what? I'll let you decide. Okay, we'll get that overview. I just summarized the entire class. You're welcome. All right. No notes either. All right. So let's start with the Abood case. Abood v. Detroit Board of Education. This involves a public school teacher in Detroit who didn't like what was being asked of him. Amy, what was going on with Mr. Abood? What was he complaining about?
The agency fees that he was required to pay because of the agency shop that was established.
Okay. Well, what is, just help us out, what's an agency shop?
So it's where they have if some members represented by the union, but also other maybe members, and so they're all covered under the same agreement, regardless of whether they have membership.
Okay, very good. All right. So is anyone taking labor law or employment law? Okay. Oh, what do you do?
Human resources.
Oh, perfect, perfection. So do you know about the National Labor Relations Act?
Yes.
Tell me about the NLRA. I'm sorry, you're Jonathan, you'll get you eventually. The NLRA, yeah.
Establishes the rules which allow unions to organize in certain work sites and also has rules that apply to other employees in the employment relationship, such as one of the most significant to me is that employees have the right to talk about their compensation.
They do. Are your employees at your company unionized?
No, but I've been through union campaigns.
Oh, they've tried to unionize, but they failed.
Yeah.
Oh, good. Another question for you. So, what's the general mechanism? You have to tell me the name of the company. What kind of what service they provide?
Still, it's tubes.
Tubes. Okay, tubes are important. Okay. So, what's the general process by which a workforce can become unionized? This is actually important.
So they have to have so many votes.
Correct.
To start that.
They have an election, right?
Yes.
So let's say the vote is like 60-40 in favor of the union. What happens then?
So I don't remember all of the rules and steps, but there's a period of time where basically the employer can present different arguments and benefits as to why their relationship is better than a represented relationship.
Right. And just, I don't want to keep picking you. Why might workers oppose unionization? Why might it actually be better for workers to not unionize? Just at least what does the employer say?
Some of it is that benefits offered may be better without the union representation because the union is looking at not just within that employee organization, but across a broader range, and so the employer may be offering better compensation.
Okay, good. Good. Thank you. That was super helpful. Okay, so there's a federal scheme. If you remember the Supreme Court case, NLRB versus Jones and Laughlin Steel. Remember that one was a Commerce Clause case that upheld the NLRA. That was the precursor to Wickard. Very, very. Never mind. I won't say anything about that case. But it was a case from the New Deal Court, and it upheld this law. And the purpose of this law was to encourage collective bargaining and to protect it. So the way it works is a union will come out and they'll say, we want to hold an election and we want to unionize our workers. And usually have the employers come out and say, oh, no, here's why it's better to not do this. And there's actually rules on what you can say, what you can't say. You can't exert pressure. You can't, twist arms saying we'll fire you if you vote this way. It's actually highly regulated. And if there's a union election, always the losing side always complains to NLRB. Always happens. Okay. Well, let's say the fact that one union does get enough votes. Not everyone agrees with it. People may have voted no, but you're stuck by it. And once you have this vote, a union is designated as the exclusive bargaining unit for this workforce, right? You could have one company with multiple unions, but for this workforce, you have one exclusive bargaining unit. And presumably, this one union represents everyone, whether they support the union or not. And this is an important point. The union must treat, under federal law, they must treat equally and fairly every employee regardless of whether they support the union or not. That's an important point. Okay. So in Detroit, they passed what's called an agency shop, which means basically you have to protect all the workers equally. But there's a consequence. The union will charge dues. You have to pay those. Even if you don't agree with the union, you have to pay the same dues. So every employee gets the same benefit, and every employee pays the same price. Good? Did I say everything fairly? Okay. Now, why is this tricky? Well, what does it mean for a union to actually engage in bargaining? That doesn't just mean that they sit around a table and they say, $5, no, $3 an hour, right? It's a lot more than that. They engage in political advocacy. And very often this means supporting candidates for office. Why? If you support candidates for office who are pro-labor, you will get better policies that require better workplace safety rules. They may have a higher minimum wage, right? There's a lot of different things that government officials can do that can benefit unions. So you're not just talking about negotiating, it's political advocacy. There's a large suite of services that unions provide, and they do this all the time, right? This is what they do. I don't fully understand it, but it's this is how these things operate. Okay. Now, what would be the problem if, let's say, there was two unions for one workforce? They would compete with each other, but they would fight for workers. They would negotiate against each other, and ultimately, probably the workers might be worse off. Maybe, maybe not. I don't know. But the government says one union, you get to have this benefit. Even though this was a case between Mr. Abood and the Detroit Teachers Association, Detroit Board of Ed, it was really about the federal government. If you notice, Justice Stewart kept saying, here's this federal scheme. We need to make this federal scheme work. These were all products of the New Deal, these justices. This was something that they understood, and so it was a unanimous 9-0 decision, not a single dissent. How far we've come in about 50 odd years. By the way, this was 1977, a couple years after Roe. The practice of the current court is not to overrule the Warren Court. I'm sorry, the Warren Court precedents from the 60s. It's the Burger Court precedents from the 70s. You got Roe, you have Abood, you have the Lemon Test, you have Bakke. I can go down the list, right? It's all these Burger Court precedents in the late 70s and early 80s that have been cut off. Oh, that's been the trend of late. Okay. So Mr. Abood was subject to two types of costs, right? One type of fee were the costs necessary to engage in collective bargaining, right? Negotiating for benefits. You have to hire negotiators. You have to hire economists, right? You have to hire secretaries, right? You have to hire lawyers to actually draft the collective bargaining agreements, right? There are certain costs which are used for the negotiations. But then there are also lobbying costs where they lobby politicians. They contribute money to political campaigns. They run ads. The United Auto Workers support, Joe Smith for president, right? That's money. So you have to separate out these two types of costs. Okay. Now, Jonathan, after patiently waiting, what is the free rider problem? This come up, I think, in both of the decisions.
That somebody will not, an employee will not have to pay the requisite dues, but they'll gain all the benefits of the union itself.
Very good. Yes. This is an economics term. If you ever taken economics, a free rider is someone who gets you ride for free. So imagine, you have a train and you have to usually pay for a ticket, and someone just hops in the back and just hold on. He's a free rider, literally, right? So the government says, Abood, you are a free rider. You're getting all the benefits of these unions, and you're not going to pay for it. And this seems to actually bother the court, right? That this person was engaging in this free riding. Okay. Now, Anna, was there actually some burden on Abood's First Amendment rights? Did the court acknowledge that there was some burden in this case?
Yes, because they said when the money was going to political issues that were against his his morals.
Like, for example, what were the examples they gave?
One of them, I guess, is like a healthcare benefit and abortion.
Yeah, so imagine the employer provided healthcare plan covers abortions, right? Yeah, this was again 4 years after Roe, so this was like on everyone's mind. What else might be the objection? It's simple.
Whether it's like a specific candidate.
Yeah, if you're a Republican and they're backing only Democratic candidates, that might again be something that you're politically opposed to. So there is a burden on the free on sort of your associational rights. Now, Adi, let me ask you this question. Was Mr. Abood being forced to say, I support Joe Smith for president, or I support, candidate Y? Were they forcing him to actually mouth words? What was the actual compulsion?
But he was paying for he was forced to pay for those activities. Well, not even, they said it wasn't going to those activities, right? No, that's the next case.
You're answering my next question. You're answering my next question. Answer this question, right? How is being required to pay for money a violation of associational rights?
Well,
you don't have to attend any meetings. You don't have to attend the Democratic National Convention. You don't have to say, I endorse Joe Smith for president. How is money forcing you to pay something compulsion?
because it's paying for the ability for those people to make that speech.
Mm-hmm. Do you pay taxes?
Yeah. Well, actually, not yet.
Well, fair point. But when you pay taxes, is your money being spent on stuff that you may not agree with?
Yeah.
You better believe it. I don't care who you are. Is paying taxes violent? Oh, you're getting up now? I'm calling you 1 second. Go. Fine. I'll get back to you. I had this one student a couple of years ago, and she always went to the bathroom. I was have to call her. Always. The one time in section, I called her at the door. All right. So, Adi, my last question to you is imposition of taxes a violation of association rights? So you have to pay for things like that?
I mean, no.
I'll give you an example in the religious context, right? Let's say you're a Quaker, you're a pacifist, and you object that your tax dollars are being spent on war, and this is a religious belief. Can you challenge the collection of taxes because you don't want to support war? The answer is no. It's not so obvious why the answer is no. The answer is no. But you can imagine how society would basically fall apart if you could challenge your taxes. So Cody, I know your name.
I'll do better than
No, he's not getting the hook. He's get back later. How is it that making Mr. Abood pay these fees in any way burns association rights? He's not required to attend a meeting. No one's saying, hey, look, Abood paid for this. This is Abood supporting this candidate, right? Where is the compulsion, Cody?
It's like the court said, like the same reason they decided in Buckley that making contributions enables like-minded people to speak.
Right.
Like,
Right. So it's right. In Buckley, that says contributing money is a way of speaking. But here, no one is. But here, he's not actually supporting the candidate. In other words, in Buckley, you give money to support a candidate. Here, you're doing none of the above. You're supporting your union. In other words, where's the compulsion? How does being forced to pay money amount to compulsion?
He doesn't have a choice at all. Right?
But how is it association? In other words, how does being forced to give money necessarily associate with a cause?
I guess because he knows where the money's going to go.
So what? Lots of money you spend on things you don't know where the money goes.
Like, we're talking about government speech. There's there's clauses that give the government the ability to tax.
Oh, there's federal law saying that the agency that you can take it. No, but my point is different. Okay, let's try this thing a different way.
Mm-hmm.
When you give money to someone, do you know what they're going to do with that money? When you buy something at a store or a restaurant?
No.
So how does being forced to pay money, which might be used downstream by someone else, associate with that message?
It's freedom to not associate with.
But how is it? That's it. How is giving money associating? Giving money to the union spends on something else. Is an intermediary. How is there forced association there?
I think it would be because without money they don't have speech.
Sure, but why is it? But why would anyone think when the union spends money on this cause that Abood necessarily agrees with this message, just because you're being forced to give these dues? Are they making him stand on a picket line? Are they making him wave a sign or attend a meeting? Try again?
No, they're not. I mean,
it's the whole purpose of the union itself. It's like to speak up for the workers.
But they never say they're speaking on behalf of all the workers. In fact, they're required to represent workers whether they agree with them or not. Right? This is actually a very hard question, and I'm doing it now, but it came up. This wasn't addressed in Abood, by the way. It came up in the second case. Oh, come on! It came up in the second case in Janus, right? And actually, they cite an amicus brief by Eugene Volk and others. And there's some argument that being forced to pay money doesn't burden your association rights at all. Doesn't burden them at all. If you're being forced to attend a meeting or salute the flag or hold up a sign, okay, that's compulsion. But being forced to spend money's fungible, right? If you give the union $5, or make it easy, give the union $10, and they spend $5 on this thing and it's $5 on that thing, you've already spent the money. You've not given your blessing. In fact, the union can say, this is the message of the union, not of the individual members. What do you think? How does requiring someone to spend money amount to burdening their associational rights? Or maybe it doesn't.
By being forced to give money to the union, you're basically strengthening their political voice.
But are you being forced to associate with anyone else, though? You're strengthening the union, to be sure. I think you're right about that. But are you associating with whatever candidate they give to?
I think it's less that you're associating with their chosen candidate, more that your money that could go towards your chosen candidate is going elsewhere. It's going towards your opposition.
Jamar, you want to take a stab?
I agree with the answer to that. Somebody that's someone else to give someone else what they want.
All right. So in Abood, the court almost takes it for granted that being compelled to make a contribution is equivalent to endorsing that cause. It's not. I think that's probably right, but it's not self-evident that's correct. They cite some historical evidence. They mentioned James Madison. There was a very famous proposed tax in Virginia in the 1780s that would require people to basically fund religious instruction and religious worship. And Madison, in his very famous papers, we'll read it later, said, no. Forcing you to contribute to fund a church is basically an establishment of religion. We can't have that. People have taken it out of context. We'll cover it later in detail. But look, we spend lots of money on taxes that we don't agree where it's being spent. Yes, sir.
I guess I was going to go in the opposite direction.
Go for it.
The same argument that you made for Obamacare, right? Where they said it was a tax instead of it being an actual.
Obamacare. What's Obamacare? I've not heard of that thing. What was that about? Yeah, you're right. It's yeah. I know a bit about it. Well, yeah. I mean, oh God, you're bringing me back. You're gonna trigger me tonight. Ready? So, is there a difference between imposing a tax on the uninsured and penalizing those who do not buy insurance? In other words, you have to buy insurance if you don't pay a penalty, or you're a tax if you go uninsured. The Chief Justice, in his infinite wisdom, really goes on forever. Said there was such a distinction. I didn't think there was such a distinction, but what do I know? Yeah. All right, but just think that through. Like, how does making you pay money really amount to violation of associational rights? Okay. And then the court goes through some of the court's precedents. This is a very famous quote from West Virginia versus Barnett. You'll see this one. It was written by Robert Jackson, who everyone just loves to crib because people like Robert Jackson. I think he had a good pen, kind of arrayed as a justice, but his writing was beautiful. And this was the case about the American flag salute, the Jehovah's Witness students. And it says, if there's any fixed star in our constellation, on our constitutional constellation, what alliteration? That is good alliteration. Constitutional constellation. Beautiful. Aspire to write like this one day if you can. I mean that sincerely. If there's any fixed star in our constitutional constellation, is that no official, high or petty, I mean petty official for sure, can prescribe what shall be orthodox in politics, nationalism, or other matters of opinion, or force citizens to confess by word or act their faith therein. Beautiful prose, right? You can't force people to adopt a message, right? That is a big no-no. Okay, welcome back. I'll call you in a minute. I mean, all the way Jamar, man, all the way around. Okay. So you can't require people to engage in speech, but they say here, there's a burden, but it's sort of incidental. What does incidental mean? It's minimal, right? There's a burden, it's not a lot. You're not requiring them to salute a flag, you're not requiring them to hold a sign, they just have to pay their dues. But the court sort of splits the baby, so to speak, right? They say, well, you know what? The dues that are used for collective bargaining stuff, you can charge those to Mr. Abood, right? You can charge those. But the dues for political advocacy, you can't charge those, Mr. Abood, right? Because that would burden too much. In other words, the burden is justified for actual bargaining activities, but that burden is not justified for full-on political advocacy. There was the distinction. Now, the obvious rejoinder is, well, wait a minute, Josh. How do you draw the line if money's fungible, right? If I give $10 to the union and they use 5 for this and 5 for that, how do you really know, right? If all the money goes into this pool, it's very hard to sort of disentangle what's chargeable and what's not chargeable. That's what can be charged to the union and what can be charged to the individual. How do you draw this line between collective bargaining activities and ideological activities? Of course, we don't care, right? That's not this case. We'll deal with this later. They wouldn't, right? Let someone else deal with it. On the facts here, on the record here, this all we have to decide is that we're not required to decide this now. Wait, is that a hand? Okay. Good. All right. So questions? Yes, sir.
Does this mean that the union said to like actually set up 2 separate accounts? Like,
Amy, do you know?
I don't.
I don't know if there were 2 separate accounts, but there were definitely 2 ledgers, right? In other words, there was a ledger discussing what was called a chargeable activity that's to be charged to the non-members and the non-chargeable. And I know that there's a litigation over time when members have said that there's, imagine this, unions engaging in malfeasance, that money is being spent in an appropriate fashion. And I'm sure there's been lots of criminal indictments as well. Look, it happens, not just at the unions, where people take money from their entity and they spend it on the wrong things. I don't care what organization you have, it happens. So I'm sure it's been violated. But at least in theory, at the paycheck level, they can't auto deduct for overtly political stuff. But it probably gets wish-washed around.
Is that be why it's the agency fee is a percentage of the actual
Yes, because let's say that this comes up with a CBA. Basically, the union says we will devote, I'll make up a number, 40% of our budget to political advocacy. That means whatever the standard union dues are, they take out 40% for out of the salary, or they take out 60% actually, right? In other words, 60% is for the collective bargaining, 40% for politics. We only give you 6% of the dues. Yes, Adi.
What is the Volk in Bode?
It wasn't Volk and Bode, but maybe Bode was bad in this one also. I don't remember. Volk argued that making someone spend money is not actually compulsion at all. Merely spending money on something is not associational burden at all. Actually, Bode may have done this, but I think Bode did as well. He seems to be on the other side in all the big cases, but that's just how it goes. I will. Yeah, I think actually, hold on, what was it?
Did you say Buckley?
Yeah, that's right. Yeah. Yeah. Bode and Volk argue that compelled dues are not a violation of the First Amendment, period, in any context. Okay. Not important for this class, but it's there. All right. Questions on Abood? All right. So Abood, again, was a decision from 1977? Unanimous, 9-0. Rehnquist joined it. All the conservatives-ish joined it at the time. Okay. But this decision became very unpopular in the 1980s and 1990s in particular, as a lot of states started pushing back on public sector unions. These were viewed as basically, how to do this charitably. When you negotiate against a private entity, you have sort of 2 sides. But when the government negotiates against a private public sector union, they're basically all sort of on the same side. They sort of agree, and they elect politicians who can give better terms. So these are considered not the best arrangements. And a number of states started enacting what called right-to-work states, which made it harder for unions to gather employees and members. But then there was a very concerted effort to overrule Abood. Because the thinking was that if you starve the union of these dues, you'll make them much weaker. and make it harder for these unions to extract, concessions. Okay. This started to come up very prominently during the Roberts Court. There was a case from 2014 called Harris versus Quinn, Quinn, Harris versus Quinn. And 5 members of the court signaled that they would overrule Abood in the appropriate case. Okay, so you had Roberts, you had Kennedy, Scalia, Thomas, and Alito. They didn't overrule them. They said, look, we're open to it. 6 months later, a case came to the court asking the court to overrule Abood. It involved Rebecca Friedrich. She was a public school teacher in California. And she objected to the mandatory fees imposed by her union. I remember this one well. So the court granted cert in June 2015, and it was like, writings on the wall. Abood is dead, right? Although Bill Bode had this one great pun. He said, will Abood abide? If you know the dude abides, you got the reference? Okay, you're welcome. Anyway, so I'll give Will credit where it's due. A petition came to the court asking to overrule in June 2015. The case was argued in January of 2016. If you listen to the argument, there were 5 solid votes to overrule Abood. It wasn't even close. And the death watch was put on, the death pool, if you will, was put on for Abood. But then what happened in February of 2016? Justice Scalia passed away. And the 5th vote vanished. So at the end of the term, or actually about a month later, the court issued a 4-4 vote in Friedrichs. You know what a 4-4 vote means? Nothing. You just affirm the lower court. So it was a 5-4 decision to overrule Janus, became a 4-4 vote. It's just affirmed the judgment. And Janus got a reprieve of execution for a couple of years. Justice Ginsburg, remember her, she told the press, this court couldn't have done any better than it did. In other words, we saved Abood, and that was there. So that was summer of 2016. Everyone expected that Trump would lose the election and Clinton would win, but surprise, Trump won the election. And instead of having Justice Merrick Garland, we got Justice Neil Gorsuch. And one of the first things Gorsuch did on the court in Janus was to overrule Abood and cast a 5th vote to get rid of the precedent. All right, so we get the chronology, right? Again, it was Justice Kennedy who was solid on this issue. He was ready to go, but just Gorsuch became the 5th vote. And this was the one full term that Gorsuch and Kennedy spent together in the court. Gorsuch clerked for Kennedy when he was a younger man. By the way, do you know that Gorsuch and Kavanaugh were co-clerks? They clerked the same term. They just don't strike me as very friendly to each other. I just don't get a good chummy vibe. They never talk about each other. You think if your colleague was your co-clerk, you would talk about them. They never do. So Gorsuch was actually Justice White's clerk, but he was a retired justice, so he was detailed to Kennedy. So Gorsuch spent the year in the Kennedy chambers. They never talked about it. It's the weirdest thing. Do you know they were in the same high school? To tell you this, Gorsuch and Kavanaugh were 1 year apart in high school.
Weird.
Yeah, same high school, the same prep school in Maryland. I'd never seen Gorsuch's yearbook. Well, I don't think they were friends.
That's what I mean. Like they was
I've never seen Gorsuch's yearbook. He's never been accused of drinking. I think he was a straight up guy. I think he always had the same white hair. But yeah, they just you would think that they were in the same high school, 1 year apart. They clerked for the same judge. You think they'd be besties? They're not. What was that?
That's what
Don't say foot of a girl and Kavanaugh in the same sentence. That's just too soon. Sorry, Brett. Too soon. Anyway, but Kavanaugh. I'm sorry. What happened was actually I was actually in the court. It was the last day of the 2018 term. They just decided. I think it was AFP versus Bonta, and after that, Kennedy went to the White House and said, "Okay, I resign. I'm retiring," and then they picked Kavanaugh a few weeks later. Anyway. All right, but let's talk about the Janus case. All right. Oh, you're back. All right, you want to give me the facts in Janus, please?
Yes. So, Janus was a public employee with healthcare and family services. It was like a child support specialist.
Mhm.
And he basically he was not happy with paying the fee that goes for collective bargaining, not the political advocacy fee. And uh, he basically said that that was compulsory speech, the payment that he had to make.
Good. And just to be clear, I think you said this correctly, but was he required to pay the sort of non-chargeable, the money for the political advocacy? So he objected to which part? Just to be very clear.
Just the what is it called, the collective bargaining fee.
Right. So he even objected to having to pay for the collective bargaining stuff, right? Cody, why did Mr. Oh no, did I? No, who am I up to? No, Aaron. No, you're not going that easy. Not the rotation. Aaron, why did he object to the collective bargaining money? Isn't that non-objectionable? Wouldn't he want to have these people negotiate better benefits for him? What's the problem here?
He argued that the deductions were a form of compelled.
Well, I get that, but I'll get to that in a minute. But what about the collective bargaining negotiation funding did he object to? Was there anything in particular the negotiating for that he was opposed to?
The lobbying and
Lobbying of whom? Who gets lobbied?
the union's lobbying activities.
Who do you lobby? You mean
The government.
politicians?
Right.
But wait a minute, Aaron. Hold on. I thought you said they weren't billing him for the political advocacy. What's this lobbying business? I thought they can't bill him for advocacy. What, lobbying? You're not wrong, Julianne.
Didn't support the public policy positions of the union.
He didn't think the union should exist at all. Period. Full stop. Right? It's not just that he opposed any negotiation or lobbying or anything. He thought this union should not exist. That its very existence was bad. That was his objection. And I mean, that's a belief. You can agree with it or not, but he thought this should not exist. Right? He did not think that the government should negotiate with itself. Right? That when you have a union negotiating with a private employer, it's an arm's length transaction. But when you're lobbying for politicians and you're voting them into office and then you negotiate with them, these politicians know if they oppose union, they'll lose office. Right? Think of the 1970 Detroit, right? If any of those politicians came out against the union, they would lose. So you're basically putting people in office who are predisposed to rule in your favor. It's not much of a negotiation. So Janus opposes the very nature, right, of lobbying, social recreational activities, anything, right? This is a mistake, and you should not be forced to pay for it. All right, everyone get this? Oops. All right, so the court then begins to sort of articulate certain principles. Ryan, a little bit of a review. Which case have we studied this semester, which sort of gets around the idea of compelled speech? Which one of the cases we studied this semester? We'll review. Yeah, where the government tries to force you to press a message. Tornillo, exactly. Again, it's not Tornillo. He was Italian. Yeah, it's Pasquale Tornillo. Yeah, during the argument, they get saying Tornillo, be high and mighty. No, it was Tornillo. He was an Italian guy. It was not Hispanic. Right, it's Tornillo. What was Tornillo about?
It was about whether you can compel a newspaper to.
Exactly right. You're on the right track.
Basically, whether you can
say, or, compel a newspaper to publish something that they didn't.
Right, right. It's whether you could force a right of reply in a newspaper, that politicians reply to certain editorial. All right. So there's this tradition in our cases that says you can't force someone to speak. All right. And again, the court quotes Justice Jackson. They love this quote. They keep quoting it in every single case. Everyone wants to be Justice Jackson. It's like their dream. Funny story about Justice Jackson. This is not proven, but he died of a heart attack early in his tenure. He wasn't that old. Where was he when he had the heart attack? So the story goes, this is not sure, but he was in his secretary's apartment when he had the heart attack. Yeah, whoops. So the thinking was that he was having an affair with the secretary and then he had a heart attack in her apartment. You can fill in the blanks. Well, and they kind of covered it up. This was back in the day where you don't report that stuff. And he just died of a heart attack. So he was a good guy. I mean, he was a prosecutor at Nuremberg, remarkable human being. Held every level. He was the assistant general, attorney general. He was solicitor general, justice. Really remarkable lawyer. But so he met his end. Too much exertion, whatever. Sorry. Okay. And then the court goes back and they quote Jefferson, they quote Madison, saying you can't compel people to engage in speech. What's that?
That's proud. I think that was funny.
It's 8:00. It's 8:30. Leave me alone. It's fine. If this was a noon class, they'd be in stitches, right? All right. The court then walks through its precedents. They say in Knox that there's a burden on First Amendment rights when you're required to provide financial support for union. What about taxes, right? This is actually a curious point. What if after Janus the government says, fine, we can't make you pay dues to the union to cover the bargaining? So impose a tax. This is Jamar's question, right? We're going to tax all public employees 5% of whatever the dues would be, and we'll give it back to the union. Can they do that? You're shaking your head no. Again, imagine Janus came out the way it did, and the government says, fine, we're just going to impose a tax on all public sector employees, and we'll hand that money over to the union. Hand it right over to them. Can they do that?
They could, but it doesn't feel right.
Oh, but they did. They did that. So this ruling, again, whenever you hear, oh my God, this Supreme Court case will change everything, nothing ever changes. People find ways around everything. They were union lawyers to figure this stuff out years ago. It makes it harder to get members for sure, but with a compliant government, they can basically achieve what they want. All right. Then we get to the question of scrutiny, right? The court says, yes, that this burdens First Amendment rights. What's the standard of review? Leighton, what standard review does the court use in Janus?
Try to decide exactly.
Exacting. Let's do a review. Where have you seen this phrase exacting scrutiny? Do you remember? What case was that? Exactly. And what is exacting scrutiny? Ooh, pun, good pun. We're not exactly sure. You might say it's not exacting. Sorry. I think that's right. That's actually very good. So exacting scrutiny is somewhere below strict scrutiny, but it's more than the rational basis you give to commercial speech. That's sort of where it falls. So it's intermediate scrutiny, maybe not. Okay. And here's the test that the court gives. The compelled subsidy, that is the money being taken out of their salary, must serve a compelling state interest. Okay, that's easy. Is there a compelling interest? Yes. But you ask, can that interest be achieved through less restrictive means? In other words, can the government achieve its interest through less restrictive means? And the court basically says, yeah, we can, right? If the government wants to support the unions, and this is so important, what can the government do? Give them tax dollars, right? If this is such a compelling governmental interest and they really need this money, don't take it from the private citizens. Just give them taxpayer dollars. Does anything stop the government from giving tax dollars to unions? No. Governments give money to lots of people for lots of things, right? So the least restrictive, the less restrictive means is to give tax dollars to the unions. I mean, I want to just take a step back and just sort of pause on maybe the irony. The reason why this case came about was because these people hated these unions. And what did the court say? Well, the solution is to use tax dollars for the unions. If there was popular support for giving tax dollars to unions, they would probably have done that already. So it's sort of like, do this other thing that we know you can't do. But that's how scrutiny works. If you can make up some way the government can achieve its goal otherwise, whether it's not realistic, if you can make it up, that's enough to defeat that what you're currently doing is too burdensome. It's not sufficiently tailored. Yes, sir.
Does that automatically make their whatever alternative they say is available constitutional?
No, that's the best part, right? The court's not saying this other thing is valid. They're saying maybe you could try this, right? Now, I think there's not really much of a debate, right? The government can spend money on unions. There's not like a debate that's unconstitutional. I don't even know what the argument would be. This was the first question I posted. It was either Anna or Adi. The government spends money on a lot of things for taxes that we have no control over. And this was actually very common in the 1970s during Vietnam, where you had these pacifists saying, you know what, I don't want to use my tax dollars supporting a war, right? Or, you know, I don't want my money being used to fund abortions, right? If governments fund abortions in some states. And the usual answer is too damn bad. As Justice Holmes said, that taxes are the cost of society and civilization, and you have to pay your taxes. If you don't like them, then you could lobby the government to change the laws, but you can't use some First Amendment or some other religious standard to evade taxes. Trust me, people have tried to evade taxes for every ground you can imagine. Wesley Snipes, whatever, right? Oh, taxes, yeah. People evade taxes, right? And they make up all dumb reasons why, and they always get in trouble. They always get caught eventually. Do they always get caught? Usually, they get caught eventually. What's that?
If any prosecution gets them.
And what's funny about the tax code, maybe you don't know this, is if you object to a tax, you can't go to court right away. You're required to pay the tax and then sue for a refund. So they call the Tax Anti-Injunction Act. You know about this, right? So let's say there's a tax that's invalid. You have to pay it under protest, and they go to court and sue over it and get a refund. So actually, to your Obamacare point, it was actually very complicated how you challenge a tax before it goes into effect, right? That's why that's why Roberts did what he did, the Injunction Act, right? If Obamacare was a tax, it hadn't gone into effect yet. You couldn't challenge it yet. So what Roberts said is, aha, the Obamacare exaction, it's not a tax for the Anti-Injunction Act, so you can sue on it now, but it is a tax for the Constitution. Figure that out. Still not over it. I wrote books on this. I'm still not over it. Every time I teach the Obamacare case, I get angry. But it has not gotten better over the years. It really hasn't. I'm talking like 12 years later. I'm still not over it. All right. Let's move on. All right. So the court says basically there is a burden, and this flunks exacting scrutiny because we could use taxpayer dollars. But then we get to the issue of stare decisis. Stare decisis. This was 2018. This was before Dobbs. But Dobbs and Roe and Casey were always lurking in the background. And I mean, poor Justice Kagan, I actually feel bad for her. She wrote so many opinions before Dobbs saying how important stare decisis was. And she was just hoping, praying that someday when abortion comes up, that her writings will have any effect. And they didn't. So I kind of feel bad for her. But the court here was applying stare decisis. Did they cite the Casey stare decisis factors here? They didn't mention it, as I recall. But they said, well, we consider those factors about stare decisis. As a threshold matter, stare decisis is at its weakest in the constitutional context, right? In other words, when you're interpreting a statute, the court applies a very strong theory of stare decisis. Why? If the court messes up a statute, Congress can fix it easily. But when you're interpreting the Constitution, you can't fix that very easily. In fact, Justice Thomas doesn't believe in stare decisis at all for the Constitution for that reason. The first sort of factor to look at is that Abood was poorly reasoned. Who am I up to? Amy, why did I think Abood was poorly reasoned?
Because of the avoiding free riders. They say it's not.
Okay, good. They say the case does not withstand careful analysis. They also say that Abood didn't really consider the difference between agency fees and public and private sector bargaining, right? When you're in a private sector, you negotiate against a private entity, that may be a good reason to negotiate. But when you're negotiating against the government whom you elect, it's a different standard, right? But is it enough for a case to be wrong? The next standard is what they call the workability of precedent. Jonathan, was Abood workable? How did it work? Was it workable?
It was not.
Why was it not workable? What was the line drawing issue we talked about a few minutes ago? No. What was the difficult line drawing problem with Abood that they did not resolve?
Being able to charge for bargaining activities and not being able to charge.
Correct. There is a difficulty. How do you decide what is chargeable, that is, you can bill them for, versus what is not chargeable, that is, you can't bill? And this is not a clear line. In fact, the court says it's been impossible to draw with precision. And as a result, the unions can often label something as chargeable, and it really is political advocacy because money is fungible. So they said this is a hard standard to develop. Another factor, Anna, is more recent cases. Was Abood eroded over time?
I think the court said yes.
Right, and which decisions eroded it? Were they recent decisions? They were. So the decisions that eroded Abood were all by the Roberts Court. In other words, over the course of 4 or 5 years, the court said, Abood is shaky. In the appropriate case, we'll revisit it. So I'll play Kagan for a minute. It's like, we're going to beat this precedent up and say the fact that we beat it up is evidence why it should be overruled, right? So the erosion came from the very court that overruled this case. It happened very quickly. Adi, what about reliance interest? Have people come to rely on the Abood decision?
I think they said yes.
What did the majority say? I know what Kagan said. Was there actual reliance interest?
Felt like I remember Justice Breyer saying it. I feel like no. Oh wait, no. Well, yes, they said it will disadvantage them to get rid of it, like they got a windfall of money. Is that right?
Kind of. My question is a little different. So, Adi, just when you negotiate a contract, how long does it last for?
Until additions or.
Okay, usually a couple of years, right? Whatever number of years, right? Okay. When a contract was negotiated a couple of years earlier, did they think Abood was the rule?
The contract.
Let's say the year before this case was decided, a contract was negotiated. Was Abood the law then?
Oh, yes.
Okay, now we overrule Abood. What happens to that contract?
What does the contract have to do with? Oh, the contract.
Well, the contract says the fees are coming from these employees. So if Abood is overruled midstream, what happens to the contract? Right.
I'm confused.
We'll finish out the contract.
But the contract is relying on people being forced to pay dues. So what happens to the contract?
So then I guess it would become void.
Or they're just having a shortfall. So what Alito says is the loss of payments from non-members may cause unions to experience unpleasant transition costs in the short term and may require unions to make adjustments to attract new members. So then, Cody, why is that not a reliance interest?
I feel like it is a reliable.
How does Alito respond to that? How does Alito respond to the argument that they should not have been surprised by this?
I guess the courts have signaled.
That's it. This is a line that really ticks off Justice Kagan. Alito says that the union should have been on notice that Abood was on shaky ground. In other words, because the court signaled, hey, we're going to revisit Abood sometime soon, you should have been on notice. And the fact they didn't was their fault, reckless. You should figure this out. What do you think about that?
So, like, I feel like we talk about this all the time in school. Like,
Tell me.
we look at what what you're doing, and you should be able to like tell your clients, yes,
Yeah. So if you were a labor lawyer, which I know you're not, but let's say you were a labor lawyer in 2017 and you're negotiating a contract and you tell your client, okay, when you're negotiating, don't presume you get these fees in a couple of years. Is that good advice? Yeah. Anyone disagree? Anyone take another position? That's probably right. If you are a competent lawyer, you tell your client, in this case, a union, this is probably going to be overruled as soon as Trump won the election. You're going to lose these fees in a couple of years. But for Justice Kagan, it's like that's not how reliance interest works. Now, to Adi's point before, they did argue that there's a windfall. In other words, this is Alito being Alito. He's trolling just a little bit, saying, look, you've extracted millions of dollars from these poor people over the years. Suck it up. You have enough to get you through this hard shortfall, right? Alito does not like the unions. You can tell that in his writing. He does not like these things. Alito is enjoying this because he's had this on his to-do list for a very long time. And then when Scalia died, he almost lost it. It's like, I got this, right? Figure this out. Alito also wrote the Dobbs opinion. So he's sort of just checking off boxes and things overall. I think they're more or less done with the big ones overall. I'm not sure what's left. There's too many big things left overall. Let's go back to, you know what? They can overrule Jones and Laughlin, Silver, and LRB. That can be a starting point. That would start things up. All right. I think I'm done with the majority. Oh, yeah. So he responds to the dissent and he says, Kagan calls us black robe rulers who shut down policy debates. But here, the First Amendment takes these subjects out of the realm of what the government can do. Okay. All right. Questions of the majority? Questions of the majority? Okay. All right, Dylan, help us out, my friend. The Kagan's pissed here, right? I mean, there's different degrees of Elena, right? Sometimes she's angry in kind of a whimsical way. Sometimes she's angry in kind of a very sad way. Here she's pissed angry, right? This is the different degrees of how she feels. I don't know what color mood ring was, but it's not a good color. Yeah, mood rings. They still have those things. What was it? What did you say? I didn't hear you.
So they took the government money.
They took the money and ran. All right. So I'll come to you in a second. So she begins. Today, the court succeeds its 6-year campaign, like the Civil War, I guess, to reverse Abood. And she cites Friedrichs, Paris, and Knox. Its decision of a large-scale consequence. Rarely, if ever, has the court ruled a decision with so little regard for the usual principles of stare decisis. There are no special justifications for reversing Abood. It's workable. No developments have eroded it, and is deeply entrenched. 20 states have built schemes on this decision. Reliance interests are strong. There's actual contracts based on this doctrine. There's no sugarcoating today's opinion. The majority overthrows the decision because it can. It weaponizes the First Amendment. This is a theme you'll see a lot. It weaponizes the First Amendment and with unleashes judges to intervene in economic policy. Lochner, she's doing Lochner there, right? You see that. Lochner, it overruled Abood because it wanted to. It picked the winning side in a debate. And she cites Roberts as a Bergefell dissent to make it sting a bit more. Today, the healthy democratic debate ends. The majority is a judge who should prevail. And it's forced the states. And it said the majority is bursting with pride. Yeah, Alito's damn proud of this. There it is. Okay. So walk me through, please, Dylan, the Kagan dissent. What I give you the bullet points to start, but what are some of the arguments that she makes?
Yeah, so she talks about like there was this like government interest in controlling the workforces and running the workforces as they self-operate. The financial support, concern that they're losing all this financial support without the way law changes. Back to the starting prices stuff.
Right. Does she really defend the Abood decision on the merits or no?
No, more like worried about the consequences of what has happened instead of like what actually going on with the merits of.
Yeah, I mean, look, so in candor, the bulk of her opinion is not really about the First Amendment. I mean, she does raise this alarm of this, and I know the word, but it's Lochnerism. It's basically using the First Amendment as a way to challenge economic regulations, right? But the bulk of her opinion is focusing on stare decisis and the court failing to give enough justification to overrule this precedent. And again, she's thinking about abortion. She's not dumb, right? She sees that Trump is in office. She probably knew at this point that Justice Kennedy was going to retire. Actually, she may not have, but she knew it was going to happen eventually. And she knew that once Kennedy stepped down, it was now a fifth vote to overrule Roe. She did not know about the sixth vote when Justice Ginsburg passed away, but she was looking forward to this. All right. But the dissent is just dissent. Abood is over. Abood did not abide, as it were. Unions have more or less recovered. They found different ways, and it's probably harder to organize, but it's not been the sort of catastrophe they predict. Whenever you have a case and someone says this will be a catastrophe, everything will change overnight, it never does. I mean, even with abortion, and this is the Dobbs opinion, people found workarounds pretty quickly through the mails and otherwise. It's never the sort of the cataclysm people predict it will be. Citizens United open up the floodgates. It hasn't been what people predict. So I always just, if nothing else, when you hear doomsday predictions about the Supreme Court, it's not going to happen. They never do the crazy thing you think they're going to do. It's always sort of more moderate. Yeah.
Regardless of their political stance, is it improper for a judge to work like this, like be looking that far ahead on?
Good question. They do it all the time. I mean, John Roberts, bless his heart, likes to play the long game. And so likes to look ahead 10 years for cases. I don't think he actually does this. I think he gave up. I think he's going case by case. But a lot of justices do have an agenda, things they want to accomplish. And it takes them many years to do it. And they wait for cases. I mean, one of the functions of the court is not just to decide cases, but to decide which cases to accept. And you need 4 votes to accept the case, grant certiorari. And very often, Justice Thomas will say, I would have taken this case to resolve this issue. And by doing that, he signals to the world, bring me more cases like this. Or I would have taken this case, but there's a problem with it because the facts aren't clean. Bring me good case, right? And then you're encouraging people to litigate this issue. So a lot of the justices signal the cases they want. It's sort of a weird thing. You think of jurisdiction that, people bring cases to the court, which is true, but the court also can request the cases they want. So it's almost like who's the buyer, who's the seller. So you're asking, is it appropriate? Well, that's what they do. Good question.
Is there any way to check them for doing this? Like,
What do you mean check
like,
that?
the checks and balances of the United States government? Like, is there any way like the Congress or executive branch can like say, no, you've overstepped?
All right, I'll give you an answer. You may not like it. I actually wonder. Well, one way the government could check that is by giving mandatory jurisdiction, right? The court now has basically completely discretionary docket. They're required to take only the cases they wish. In the past, they've had mandatory jurisdiction. For example, if a case was brought as a constitutional challenge, the court had to take it. Now they might dismiss it with one sentence. They had to actually take the case. I think Congress probably should increase the court's jurisdiction. They're deciding very few cases, by the way. This is maybe something you've read about. The court used to decide hundreds of cases a year, like 400 cases a year, 300 cases a year, 200 cases a year. When I was in law school, it was about 100 to 80 or 90. Now they're down to about 60. They're deciding so few cases. What the hell are they doing with all their time? I mean, my goodness, you go to any trial court judge in Houston, Harris County, they're deciding hundreds of cases a month. Hundreds, right? Julian, am I right? Supreme Court, there are 9 of them, and they decide about 60 cases a year. That's like 5 or 6 opinions per judge. 5 or 6 opinions per judge. Exactly. And if you force them to do more work, it'll be less 100-page opinion. Who wants to read this crap? I don't. I have to, but I mean, oh man, if I had my way, right? I wouldn't give them. You know what I make them do? Go circuit riding. So back in the day, the justices had to ride circuit. They had to get on their horse and go to the different courts around the United States and hear cases where the people are. I would bring that back in a heartbeat. You don't need mandatory retirement ages. Just make them ride circuit. Give them a full-time job. They will retire at 65 because they don't want to do it anymore. I'm serious. They got a cushy job. They work on the first Monday in October. They end in June. They hear cases about 2 weeks out of the month. They're out the other side. They're traveling around the world, going to Aspen, going to Zurich, wherever they want to go, right? I would make their lives miserable to get them out of the court earlier. I would eliminate law clerks. I'm actually thinking of it. Do your own work. If Marshall could do it, if Story could do it, you can do it. You don't need 4 law clerks. The reforms I would. What's about judicial reform? I would give real reform. None of this nationwide injunction stuff. Actually make their jobs difficult. They don't do it. Focus on your work. Focus. Do your job, not all the stuff. We don't care. You're writing. Oh, just write another book. Right. Write another book, which no one's going to read. I pre-ordered it. Right. They always write these books, which no one reads, but we all buy. They just send shells. They're very pretty. Okay. Other questions, yeah. Come on. Evaluations. Blackman rants about buying books he doesn't read. Okay, that's true. Okay. Any other questions on Janus? Okay, so again, these were the cases about compulsion to pay dues. The next case is really new. It's of recent vintage. In fact, it was decided, I don't know, about 8 months ago. So it's not even in your book yet, but I gave you the PDF for this. You're welcome. Actually, no, you have to buy your book, so you're welcome. You're welcome. Good. You all got the books for free, right?
Oh yeah.
Good. No, if you pay for it, but no, I had enough copies. And I'm like, oh, I have 20 students. That's actually perfect. Okay, good. All right. 303 Creative versus Elenis. So this is an issue that has been percolating in the courts forever. When I first started teaching here, there was a case from New Mexico called Elaine Photography. I might be off on the name, but involved a photographer who did not want to photograph a same-sex wedding. Okay. And this actually happened that someone offered to hire her for a wedding, for a gay wedding. She said no. This was litigated throughout the courts. And this issue popped up over and over again with a photographer, with a baker. His name was Jack Phillips. He runs a masterpiece cake shop outside of Denver. Actually, I was in Colorado. I went to visit there. He was on vacation that week, so I didn't get to see it, but I went to go check it out. You've had, again, photographers, bakers. You had a florist, Arlene's florist, Baronel Stutzman. She's in Oregon, memory serves, Washington State, one of the corner ones. And she objected to doing floral arrangements for same-sex weddings. You had another one called Sweet Cakes, Melissa Sweet Cakes. They made various baked goods. Yes.
Just out of curiosity, how many of those cases do you think are manufactured?
All of them.
Okay.
Just about all of them.
Okay.
I mean, no, not all of them. The florist one, Stutzman, they were actually very unusual facts that I recall. The florist had a long-term relationship with this gay couple, and she'd done a lot of arrangements for them. But when it came to doing the floral arrangement for weddings, she declined, said, "I can't do this for you." It was actually a kind of a moment saying, I really like you two, but I won't do this specific service. With the case in Colorado, again, he would do other things, but he wouldn't do this particular thing. So unfortunately, a lot of these cases are contrived, where you have people basically going to a business they know won't provide the service for the purpose of creating a lawsuit. After Jack Phillips, or while the litigation was going on, but Jack Phillips with a gay wedding, a transgender person asked to make a cake for a transition. It was like, I guess either pink on the inside, blue on the outside. I can't remember the colors, but it was a transition cake. And they went there for the sole purpose of basically asking a person to make a cake that they knew he wouldn't make, and to bring litigation. I mean, it was it's done deliberately. But there is a long tradition of testers. You know what testers are? So when there was very rampant housing discrimination, what you would do is you would send a white person to a building saying, "I'd like to rent this apartment." "Oh yeah, sure. Here's an application." Then you send a black person to rent the same unit. "Oh, I'm sorry, we're full. Right? We don't have any more units." Right? So there's a long tradition of testers who go to businesses to see if they're having discrimination. There's nothing unique about the wedding providers, but it's just people rubs you the wrong way. I don't know. Right. So the issue with the photographers, the florist, the website designer, first off, is there actually speech? Right? With baking a cake, is that speech? If you're a baker, you might say yes. If you're an eater, you might say no. Is a floral arrangement speech? Oh, that's harder. Is photography speech? Yeah, it is. Right? And what's unique about photography is you have to actually go there and film it yourself. It's not just sitting in your own studio. You have to actually be at the ceremony. What a website. Is the website something off the shelf? Is it designed customized? It becomes an issue here. All right. So in Mastery's Cake Shop, which is referenced in the reading, the court did not decide the First Amendment issue. Instead, they decided it on very Anthony Kennedy grounds. This is in 2018. And they said, religious animus, what happened? As this issue is being litigated through the state court system, members of the Colorado government made these sort of disparaging remarks at religion. How religion is basically just a cover for discrimination, that these religions are hateful of gays and lesbians, and just the negative stuff for religion. It wasn't really relevant, it was in the record, and the court found that under the Lukumi standard, there was targeting of religion. We haven't done that yet. The court found that there was targeting of religion, there was animus, and as a result, you couldn't enforce the law against Jack Phillips. So in Masterpiece, Kennedy was in the court, they sort of punted on the issue of First Amendment protections. In Elenis, the court granted squarely to consider, is the First Amendment, or does the First Amendment provide the defense against this government action? All right. What do we have to? I don't remember. Who was last? What are you doing? Yeah. What's the public accommodation law? Oh, you're right over here. I have to walk all the way over, man. You keep drifting.
If you're offering service to a public-facing service, you have to accommodate every potential buyer, no matter what class they find themselves in.
What you're correct, but what is a public accommodation? Maybe that question is a little more specifically. What's a public accommodation?
I think it's any sort of public service that
Mario, how about what's a public accommodation?
Public accommodation is a private or government-owned business, facility, or organization that provides goods and services to the public.
A public accommodation provides goods to the public. Okay, that's good. Give me an example, maybe what a public accommodation might be.
The bus,
The bus. Okay, what else?
pay for.
What about a hotel?
Yep.
Restaurant?
Hotel, theater, restaurant.
Train?
Yep.
What about a private country club? What about a church or a synagogue?
Yep.
That's a public accommodation.
I would say so, yeah.
Would a church be required to admit people not of their faith?
I think the difference between a private country club and a church is that anyone can walk to a church, but
Is that so? Have you walked? Is there a place you can't walk into? Well, if they say the door only people of our faith are allowed to enter? Those exist.
well, that'd be a religious step.
So public accommodation, any characteristic. Aaron, how do you define a public accommodation? This is actually an important point. Let me go on just for a little bit more. How do the courts define a public accommodation? What's a public accommodation? I'll make this easier. Is a website designer a public accommodation? Is that buzzing all the time? That light, you hear that? No, that's projected buzzing in this light bulb. Anyway, Aaron, is a website designer a public accommodation?
I would say no.
Can I? Does Laurie Smith have a storefront? That anything in the case? Can I walk into her house where she designs websites? Can I pick up a website off a shelf? Say, I'd like one of those, please. You put in a box.
Nope.
Can I,
Not.
So what the hell are we arguing about? Why is a website designer even? Why does this case even matter for talking about public accommodations laws? Right? She has no store. There's no off-the-shelf website. It's not like a CD-ROM or a flash drive, if you will, right? It's something that's built. What is this case even about?
It seems like it's just trying to apply the public accommodation.
Then that's what is a public accommodation? That's what I'm getting at this row, right?
It's compelling service providers.
What kind of service providers? To get this case, what's a public accommodation? Julianne? Everything. Everything. Everything is a public accommodation. Everything. Everything. Right? So at common law, I think Jamar was getting this a minute ago, we said a bus or a train, right? At common law, a public accommodation is basically a common carrier. Remember that phrase, common carrier? A train, right? A ferry service, a hotel, right? These were viewed as common carriers because they basically had a monopoly, right? They were the only ones in town that did this ferry. You had to serve everyone. But over the 20th century, the concept of public accommodation exploded, expanded, right? To include not just hotels and restaurants and theaters, but virtually any business, a supermarket, right? A parade in Hurley. In JC's, a private organization because they use facilities, right? Virtually anything now is subject to discrimination laws. You might think, okay, that's good, Josh, right? Everything is subject to these public accommodation laws, any business you want. Now, Justice Sotomayor sort of quips her into dissent. Well, Steven Spielberg's not a public accommodation, right? Or Banksy, right? Doesn't serve everyone. Do you think most artists can exist if they don't advertise their services? Not really. So if you're basically any business in the world except for some wealthy producer, you are a public accommodation. Congratulations. You may not know this, but you are. And thank you. And as a public accommodation, you're subject to all these different rules of who you can and cannot serve. Okay. So Ryan, just give me the facts. What was Mrs. Laurie Smith's business? What did she do?
Creates custom websites using like basically create, it takes what the person trying to market, whatever sold off the website. On the original video.
Ryan, let me ask you a question. Has she ever actually designed a wedding website before?
Say that again?
Has she ever before actually designed a wedding website?
Oh, yeah, I think so. No, so she had not.
Does this go into your point about the judges kind of choose what cases are tailored for their agenda?
I'll get that. I'll get that.
Yeah, she has.
Oh, you're. I'm gonna get there like in 1 minute. Okay, I promise. You're right. You're right on target, my friend. You're right on target. So right. So the first thing to note is, and Justice, was it Gorsuch? Right. It was Gorsuch, right? Yes, Gorsuch. Gorsuch explains this. He's like, she designs websites, and she wants to start designing websites for weddings. That's framed very delicately, because what that means is she's never actually designed a website wedding before. So actually, Ryan, this was your question a minute ago. I'm going to phrase this question very carefully. Did anyone ever actually ask her to build a website for a same-sex wedding? Is this like the guy who walked into Jack Smith's cake shop and asked for a wedding cake?
You asked me to do the same thing.
I'm asking you, does it say in the opinion that someone asked her to design a wedding website for a gay wedding and she declined?
Yeah.
Then what the hell are we doing here?
I think they know that her views on marriage are known by somebody. They know, and she knows that if she's ready to get in the website, wedding website, then she's going to be challenged.
So there seems a lot of speculation there. So you said she knows what's going to happen, and he knows what's going to happen, right? Jamar, you want to come back to you? Yeah, because you sort of signaled what you were picking up before. I don't want to cut you off.
Yeah, that's standing.
Okay, so there's a question of standing, and this was, I don't want to say manufactured. These are test cases, right? Everyone brings test cases, right? Everyone brings test cases. And what a test case usually says is, this law has not been enforced against me yet, but I fear that the government will prosecute me for this. So I want to bring an anticipatory suit to challenge. For generations, people on the left brought test cases. Civil rights advocates do this all the time. And the conservatives cried foul, saying, there is no standing, right? You're making up a case, this is manufactured. And as I said at the outset of class, things change, things flip. So in this case, it was conservatives bringing the pre-enforcement challenge, arguing that their fear of prosecution gives them standing. So to Jamar's question, which I thought was a good question, right, about the, if the justices pick and choose their cases, the wedding case is more or less dried up, right? People don't bring these cases anymore for a very obvious reason, because there are very few businesses that actually refuse to cater to gay weddings. The number has got to be in the single digits nationwide, maybe double digits, right? The number of actual businesses that say we will sacrifice our profit and take a stand and litigate this issue, there are only a couple of them left. So the court probably said, all right, this is going to be one of the last ones. Got to do this one. Poor Jack Phillips in Colorado is, whistling in the wind. But, I'm not sure if a cake is actually speech. Oh, website speech. That's good. Right. That's clearly speech. So this is one of the last few cases they could have taken. Now, again, there was a case involving a florist. The court, poor old Baronel Stutzman. This woman was almost 80 years old. Eventually, she settled the case because she was too old. She just couldn't handle it anymore. But they wanted to decide this issue, Jamar. So your question is, do they pick the case they want? Yeah, they picked this one. This was basically a custom-made case, no pun intended, that was designed for review. Now, I think there was standing. I actually, personally, it's not, not in the case, but I think a fear of prosecution was likely. I think the precedent shows that she would have an injury. Now, this did come out. I'll just flag this. After the case began, either someone emailed her or left a voicemail saying, "I want you to make a gay wedding for me, a website for a gay wedding for me," and that was put inside the pleadings. But that email came after the complaint was filed. And standing must be established when the complaint's filed, so actually it doesn't even matter. This was a big kerfuffle. We always find these things later. We'll talk about when we do Kennedy v. Bremerton later. This was an issue also about whether whether the football coach was actually fired. People always try and throw a muck in the works. All right. So let's just assume they're standing. It's not federal courts class, but we'll assume they're standing, and we'll get to the issue. The court walks through the precedents, and they cite which case? Same, West Virginia versus Barnett. They always cite, right? They always cite this case, same exact quote. They also cite this case, Hurley, this name, versus Irish American Gay, Lesbian, and Bisexual Group of Boston, 1995. And this was the St. Patrick's Day case I mentioned earlier. You had a marcher who said, I am a gay group, and we want to march in the parade. Isn't a parade a public accommodation? The court held that, whatever the public accommodation law said, the First Amendment prevailed. Now, why is this important? Having a parade is about conveying a specific message. And by allowing this group to march, you'd be changing your message, and the government can't force people to alter their message. Okay? You had Boy Scouts against Dale. This was the Boy Scout case with the gay scoutmaster. And forcing the scouts to include Dale would interfere with the group's a point of view and its beliefs. You cannot do this. Right? In short, the government cannot compel people to engage and speak a preferred message. Lena, we're up to you again? I think we are. Our website's pure speech, not just speech, pure speech. That's the phrase they keep using over and over again. Why are websites pure free speech?
Business it's time to communicate ideas.
Is a website taken off the shelf? How does a website come into existence? Right. It's customized in creation. Now, this is a point about litigation. Do you know what a stipulation is? Okay, so in any litigation, the parties, you can say yes, it's fine. In any litigation, the parties stipulate the facts. They agree on stuff. Why is that important? You are bound by your stipulations. If you're a lawyer and you say, we agree with the defendant on X, you're stuck with that. You can't change your mind later. For reasons I still don't understand, the Colorado government stipulated the facts. This came up a lot, if you noticed. They stipulated that the websites are customized, right? They stipulated that they communicate ideas. Why is it significant? Once you make that stipulation, you agree that this is speech. Now, Justice Sotomayor in dissent said this isn't speech, this is conduct. But she was fighting against the stipulations. If Colorado had not stipulated these things, I don't know the opinion could have written this easily. It's been a harder opinion to write. So again, a lesson for you lawyers or lawyers to be careful what you admit. Because when you admit something, you always say you file a complaint and then you do an answer, right? I agree, I disagree, I agree. If you agree to something, guess what? You're stuck with that. So if you're the trial lawyer and you say, whatever, I agree to this, whatever, no big deal, then your Supreme Court lawyer comes back 3 years later saying, you idiot, why did you agree to that? Stuck with it. Amazing, right? So this was a case that really turned on the stipulations. So Colorado here seeks to compel the speech. It forces her to create custom websites celebrating marriages that she does not celebrate. And this is a point who am I to? Amy. Gorsuch makes this point over and over again. He says that Colorado is trying to eliminate dissenting ideas from society. He says this several times. He says Orwellian. What is his point that Colorado is trying to eliminate dissenting ideas about marriage? What is that?
Maybe to by having this statute to get everybody on board, like this is where we're headed. And
so, what if you have traditional views on marriage? You oppose gay marriage. What does that mean? Can your view be tolerated in the marketplace?
basically, no.
Right. Gorsuch is very deliberate in this point. I'm going to explain to you why. He's not just saying that they're making her build a website. It's their motivation for doing so is to eliminate dissenting views on marriage, that you can't even hold these views. Now, if we think back to Obergefell, Alito's dissent, he had this one line that was very memorable. He said, maybe in the future people can hush and they can whisper in the corners views on marriage or traditional, but they can't do this in the open. And then Justice Kennedy said, of course not, right? We have robust protection of views. And They're channeling now the Kennedy Alito discussion from Bergerfeld. That's exactly what they're targeting. That you cannot even hold this view in public without being sanctioned by the government. Anyone see that? Okay. The court repeats that coercion is unconstitutional under Hurley, under Dale, under West Virginia versus Barnett, and they're putting it to a choice. If she speaks, she must speak as the state demands or face punishments. Right? She has a choice. Now, the dissent says she has a different choice. Jonathan, what's the other choice she can make? She doesn't have to speak at all. What's the other choice she can make? If you don't want to make websites about gay weddings, what might you do? What could she do? It's on your notes. If she doesn't want to make wedding for gay websites for gay weddings, what's her option? She has a lot of things she can do.
Not get out of the wedding business.
Don't make wedding websites. Say on your website, I will not make wedding websites, period. Would that be illegal?
No.
She could do that. So Sotomayor said the choice is a false one, right? That there is no choice. Now, Anna, what's the response to that? How would the majority respond to that argument?
She wants to make wedding website.
Right, she wants to, but why does that matter?
It's her First Amendment right to expressive speech.
But isn't this a public accommodation though? Couldn't you just choose not to have that accommodation?
Or she can make it for her own and not profit off of it.
Does profit take you outside the realm of the First Amendment? In other words, you lose protections when something's paid for.
No.
No, you don't. Okay. Right. So here's the argument. What the majority says is you can't put someone to that choice. That the only way they can engage in their speech is they choose a certain message. You can't impose that compulsion at all. That someone wants to engage in any area of speech, they must choose whatever perspective they want. You can imagine the government says, okay, you know, you don't want to write a newspaper, write a newspaper, right? Go do something else with your life. Now, Justice Gorsuch gets what I call the parade of horribles. You know what a parade of horribles is? Where they list a lot of hypotheticals that sort of tease out where things go, kind of like a slippery slope. So, I forgot to mention. So I did an amicus brief in this case that got mentioned argument. I'll play it in a moment for a group, the Jewish Coalition for Religious Liberty. So this is Alito, who's scrutinizing the lawyer for Colorado, Eric Olson. Ironically, he was actually the lawyer for the insurrection case. So I met him at the court a few weeks ago. It's a small world. It's incestuous. Everyone's the same people. All right. So I'm just going to play this audio. Doesn't need a setup. Oh, audio thing. I'm sorry. My setups are so good, and then the audio thing kills me every time. Output speakers. Okay. I was actually in the elliptical time. I wasn't even listening to it. Like all these texts, like Josh, you're talking about. I'm like what? All right. So again, here's the hypo that I came up with, right? And actually, it was myself and my colleagues. I didn't do it all by myself. So the colleague hypo is like this: website designer says, 2 Jewish people, I'll make your wedding website, right? But for intermarriage, I will not, right? Because Jews don't favor intermarriage. Okay. So Eric Olson does not like that question. It was my brief, so it's fair game. So in other words, you would have to make the website for intermarriage with all these Jewish themes on it, right? And you have to put all these messages saying that interfaith weddings are sinful, but let's make the website anyway. By the way, why would anyone ever want to hire a vendor for a wedding who doesn't agree with their thing? Anyone ever gonna have a wedding? Everyone married here? Would you hire a wedding vendor who like disagree with your entire existence having a wedding?
There's so
No,
many to choose from.
they're so. I mean, we'll get to the Sotomayor dissent, and she says, you know, the sign, you walk in, no Jews, no dogs, right? Right. But just as a realistic matter, no one is hiring Laurie Smith to do a wedding for a gay wedding. It's not going to happen. It will never happen. Which is maybe why Jamar's right. There's no standing because no one will ever hire this woman for a job, right? That's Kagan, by the way. So I came with this example. So again, the first hypo is photographer, take a picture from my JDate Pro, it's a Jewish dating service. And so Leo's like, I think that's a Jewish dating service, and Kagan's like, it is. Yeah, so it's about to actually get very bad. Alito steps in a big league. Um, oh God, oh Alito, Sam, why do you have to do this to me? This made CNN, by the way. Josh Blackman's brief, and so just yeah, that's why they hate me. So Ashley Madison is a dating app for infidelity when you want to have an affair.
Yeah.
When married people want to have affairs. So yeah, so again, Josh's hypo was you take a photograph for a JDate for a Jewish dating site, that's good. And he took the same photograph for Ashley Madison, which is an infidelity website, which infidelity is bad. So the problem was Alito goes to Kagan, you'll be familiar with the next site. Thomas is laughing at Thomas. No. Oh. Ooh. Sam. Okay, it goes on. All right, so you're welcome. So this was my amicus brief. Gorsuch, I don't think likes me as much as Leo does. Doesn't mention our brief, but he gives examples. You know, imagine a movie director required to make a Zionist message film, or a atheist person required to make a mural about God, where they have to do these messages. So you give these examples all day, and until the cows come home. I think the fact is, no one is actually asking Laurie Smith to actually make this website. It's kind of a contrived case, but I think there was standing, and lots of these sort of tester cases are contrived, but under doctrine they have standing. If you want to reverse a doctrine, you can go ahead and do that. Now they get to this point about the sort of alternative argument, and this one's actually a little bit hard to follow. What the government argues here is that Smith only has to repurpose the website she makes for a different couple. In other words, let's say she makes a website for a man and woman getting married. She already made it. She must sell the exact same product to another couple. By a similar token, let's say that you have a cake that's on the shelf and someone comes in and says, I want this cake for a gay wedding. I think, Jack Smith would probably sell them that cake, but he doesn't have cakes on the shelf. He only makes customized cakes. The challenge here was the stipulations. They said that each product is customized, right? You can't just like take a website and put in a box, put some string, some wrapping paper on it. That doesn't work. You have to customize the website. You have to change the name from Adam and Eve to Adam and Steve, right? You have to make it a customized website, as it were. All right. So I don't think this argument got much play. Justice Gorsuch responds to the dissent saying, are we talking about the same case here? Right? Because you go on about this history of public accommodation laws and gay rights, but this case is actually very narrow. What about the argument this is conduct and not speech? Who am I up to next? Adi, are you next? Adi, what's the difference between conduct and speech? This comes up a lot with the majority in the dissent.
Expression that she would be making in the video saying that this is an
Right, but again, that's right. But what is the difference between conduct and speech? How do you draw that line between conduct and speech?
Well, sort of trying to draw it, but it's basically, conduct can be speech. Things that you do, their conduct can be speech if they're expressive.
So I'll give you an example. We'll do this in the religion clause in another week or two. Conduct versus belief. Let's say that I believe in polygamy. That's my religious belief. And then I carry out that belief by engaging in polygamy, having multiple spouses. Is your religious belief protected? Can the government say you can't believe that?
Because you can believe it. But
what about your conduct?
But your conduct is, there's a different weighing of the scrutiny for whether or not.
All right, so let's try a different one, right? Let's say my belief is that as a Native American, I must engage in certain rituals with certain types of peyote and the like. And now, as conduct, I'm going to ingest that peyote and use a hallucinogen. Different?
No. Well, yes, in that case, it would be no, that they can't do that because it's a generally applicable law.
Oh, you give me Smith. All right, good. We're going to start. Are we starting religion next week? Yes, we're starting religion next week. So it's a good preview, actually. There's a very long-standing debate in First Amendment circles, the difference between conduct and speech and conduct and belief, right? If you say something that's either speech or belief, it's given very robust protections. But if you sort of degrade it just being conduct, you can regulate the heck out of it. So there's a lot of discussion of the difference between conduct and beliefs. The Reynolds case is actually the polygamy case, and the peyote case is employment division versus Smith. We'll read those ones in class next week. Next week the readings are a little bit heavy, so just give yourself a little bit extra time. All right, let's go on to the dissent. The dissent really tries to make the point that this is the first time that you're given a basically a First Amendment defense of public accommodation law, which is true enough, but the exception though is Hurley, which was a parade that was a public accommodation case, and Dale, Boy Scouts, was also public accommodation. So they sort of narrow it. That's the first time you're granting a business open to the public. So it's not just public accommodations, but a business. And they put a lot of weight on the fact that it's selling a commercial product. Now, when you're selling a commercial product, this is just mere conduct. It can be regulated. We return to the question of whether we're dealing with a speech or conduct. A lot of it kind of circles back to this question. They give this example of, I don't know if you noticed the footnote, of a young Jewish girl who sees a sign that says no Jews or no dogs. That was actually a very famous quote from Justice Ginsburg confirmation hearing, where she saw that sign as a child. Ginsburg had actually died a couple years earlier, so I think they're still sort of channeling her memory with that quotation. The court goes through precedents like Heart of Atlanta Motel. Remember that one? This was a Commerce Clause case that also involved Title II of the Civil Rights Act, which said you do not have a due process right to exclude customers from your business. Cats and Vacuum McClung. This was about the racist barbecue in Birmingham, right? This restaurant, they would serve black customers to go, just not table service. And they said they had a due process right to do this. The court said no. Another case which we did not read was called Newman versus Piggy Park. This was a grocery store, I think in Alabama, but I might be wrong on that one, where they have a religious objection to integration, that it would contravene the will of God to serve black customers. It was actually the religious belief. And the court said this was patently frivolous. So you can see what Justice Sotomayor is doing, right? She's trying to tie the sort of arguments that Laurie Smith is putting forward with the racists from Katzenbach, Heart of Atlanta, and the Piggy Park case. And she's saying this is part of the same tradition. And then she says, in the past, the court was courageous, right? The court stood up for discrimination. But my, how times have changed, she says. Now the court's siding not with the oppressed people, but with those seeking to, I guess, do the oppression, or as it were, right? She's staying on the other side. In the past, the court stood up. Today, the court shrinks. Right? The dissent also says that you would apply basically O'Brien scrutiny. Nick, why does Sotomayor want to apply O'Brien level scrutiny?
I think because you would apply that if you're not dealing, I think, with your speech, it's conduct.
Exactly. And then the line between conduct and speech is important. Why? O'Brien was about expressive conduct. Remember that? Is burning a draft card speech or expressive conduct? If I say, pardon my French, fuck the war, right? That's pure speech. There's a case about fuck the draft. We'll do that one. We'll skip that one. I didn't do that one. Anyway, Cohen against California, the case was having fuck the draft on the back of your shirt, right? Or back of your jacket. That's pure speech. But if I burn a draft card, I am opposing the war through conduct. And O'Brien is about conduct. This is why it matters. If you're doing conduct, you're in O'Brien scrutiny land. If it's pure speech, you're in strict scrutiny land. It makes a huge difference how you characterize it. I mean, I don't have my chart on the board, but what's the very first question? What are we dealing with? Is this speech or is this conduct? The very first question. They don't even agree in this case on the very first question, which is why the stipulations made a difference here. Colorado, for reasons I don't know, stipulated this is speech. And once you do that, you're on a fast track to strict scrutiny. You're not going to win this one. So because this is O'Brien scrutiny, she says, look, this promotes a substantial governmental interest. Yeah. Would it be harder for the government to achieve equality without this law? Yeah. This law helps the government achieve its goal. That's good enough for O'Brien scrutiny. Any burden is just incidental. That is sort of trivial, minimal, right? It's not really that important. This is no different than the Ollie's barbecue, who would not serve black people inside, they'll serve them outside. And she's trying to create this sort of separate but equal analogy of how these businesses operate. Okay. She closes, today is a sad day in American constitutional law and the lives of LGBT people. The Supreme Court declares that a kind of business has a right to refuse to serve members of the protected class for the first time in history. She says this is a license to discriminate. Again, so Kagan said, weaponizing the First Amendment, license to discriminate. These words have meaning, and people actually pick up on these very well. Okay. Questions on the Sotomayor dissent in Elenis? Yeah. Hmm? Oh, it's a good question. I think the stipulations do narrow what is speech. In other words, it's not clear to me that this decides that cake is speech, that the Masterpiece Cake Shop is speech. Flowers are much the same. I think the court, to Jamar's point about picking their cases, they might just turn away the cake case. They leave us alone. We decided this already. Poor Jack Phillips will just be left to the wolves, and he'll be fine. I don't know how much this affects the social media case because, well, maybe I should argue differently. If I type something on Facebook, right? That's my message. That's protected speech. If Facebook generates something with an algorithm, is that speech? The question of what is speech is actually very hard. This came up last week with the arguments for the social media case. I don't know how it shakes out. I don't know actually. Again, this case and Masterpiece Cake Shop, I don't know how much juice they have. In fact, I don't know if I want to put this case in the textbook the next edition. It's actually a very hard question. You don't always know right away how important a case will be. And I don't know, maybe I haven't decided yet. I gotta talk to Randy about it. He hates taking cases out because it's actually, you teach a case for years, you get to know it. I didn't assign JC's or Boy Scouts v. Dale. It's in your book. You can read it if you want. I didn't assign them because I think it's just those are cases from a different era, but maybe you need to know them both. I don't know. Questions? Yeah, buddy.
How do you reconcile, I'm gonna play devil's advocate for a minute.
Of course.
Justice Sotomayor talked about how, it wasn't okay if you were denied by one restaurant, but you had the ability to go somewhere else to another restaurant. And telling the website designer, like, you actually don't have to, like, you can do some work, you can have another career, you don't have to actually do this.
Yeah, I think the argument is, again, a restaurant is not really a customized service they have a First Amendment right to exclude, whereas with a website designer, you're making each one sort of unique. But you might argue every dish that a master chef makes is an act of expression. And this is why they didn't want to do the cake case, because it's actually very hard. I think what about a wedding DJ playing discs at a wedding? Is that protected speech? Having to play like, Here Comes the Bride for a same-sex wedding, right? Yeah, I don't know. Yeah, Jamar.
Is it kind of the same policy argument that comes up in contracts where you don't enforce specific requirements, you don't know what the outcome will be?
That's a good thought. Yeah. Yeah, I mean, the idea of you don't compel people to do stuff is reflected in contract law because we have a doctrine against specific performance. You don't like doing it. I think for an obvious reason, if someone opposes your union, you don't want them behind the DJ booth, right? You don't want them behind the photographer. They're gonna do a crappy job, right? This is why you prefer damages to specific performance in the case of a breach. You don't make them execute the contract. Whereas here, they would basically make Ms. Smith execute the website and actually do the website, which will not be very good, I don't think. I mean, if you don't have your heart in something, it's not going to be good. What else? All right, let me wrap up. Let you guys go home. So the case that we did today sort of tracked two elements of the associational right. First, we talked about Abood and Janus, that making someone pay money to a government, a public union, is in itself coercing them because they're compelling them to engage in a certain message. And likewise, in 303 Creative, if you design websites and you have this public accommodation law, you're making someone endorse the state's message about marriage, and you're basically limiting dissent, at least what the majority says. Okay? None of these cases actually involve pure speech in the sense that, people are saying, I want to say this, and you're not letting me. It's actually the opposite. I want to stay silent. I don't want to say it. You're making me say it. So it's almost two sides of the debate. Earlier in the semester, we had, I want to say this, but you're telling me I can't. Here, it's, I don't want to say this, but you're making me do it. And that's what the associational case is about. It's compelling you to do stuff you don't want to do. Okay? Next class, we will begin the religion topic. And the readings are a bit heavy, so please give yourself some extra time. Okay? Any questions? Have a wonderful evening. Adi.
Didn't one of these cases talk about prior restraint? Or did I make that up?
Right, that was the Sedition Act stuff about you can't impose prior restraints on speech. They're so rare. I mean, maybe Brown against EMA and Snyder herself, those are prior restraints that they ban what you could say in advance.
I meant like.
Come on up. I don't want to keep everyone late. Yeah. Thanks so much. I'm not sure.
Some things like something about prior restraint.